Hi, I'm Jeff Mandell, co-chair of Stafford Rosenbaum's Appellate Practice Group. This is the last of 4 videos about oral argument earlier this week before the U.S. Supreme Court in the takings case of Murr versus Wisconsin. The first video set out the facts of the case and how it came to the Supreme Court. The second video talked about what the governing legal principles are before this case. The third video explained the arguments that all parties made. And this last video is going to talk about what happened at oral argument and what little we can glean about what we expect to happen next. Oral argument is a time for the justices to gain a better understanding, to probe the limits of a party's position, and to test different theories. The questions asked at oral argument don't always illuminate which way the case might come out. Sometimes they do, and it seems fairly clear that a majority of the justices are cohering around a specific argument or a specific issue. But sometimes that doesn't happen, and this is one of those latter cases. After the oral argument, the outcome of this case seems more muddled than ever. The justices seem dissatisfied with all of the options presented to them by the 4 lawyers who presented separate arguments and theories of the case, as discussed in our third video. Chief Justice Roberts seemed, of the court, the most amenable to the Murr's approach that the lot lines are the most common definition of a property and should be used in this case and in other takings cases to decide what the relevant parcel is for a takings analysis. Justice Kagan, on the other hand, asked questions that were more in line with the state's view, suggesting that she didn't understand why lot lines themselves should be determinative when there are other issues of state law that could also factor in. Yet Justice Kagan also asked questions pushing back on the state's rejection of issues outside of state law, saying that while she thought all the issues of state law were important, she wasn't sure why additional considerations should be rejected. Justices Kennedy and Breyer, for their part, asked questions that suggested they have a preference to consider multiple factors here. But they and others who spoke at the argument did not seem to cohere around or have settled on a sense of which considerations would be relevant to making this determination, either in this individual case or as a general rule going forward for future cases. So while it seems likely that the court will adopt a more flexible test rather than one of the bright line simple tests offered by the Murrs and then separately by the state, it's not clear how broad that test is going to be or what factors are going to be relevant to that test. Without a clear sense of what the test is going to be, it's quite difficult to handicap how it applies to the Murr's specific claim. Most likely, the Supreme Court decision here will require the Murrs to go through more litigation, and almost certainly it will launch additional takings litigation to refine and define the test that the justices set forth in this case. We expect a decision in this case sometime in May or June, and you can stay tuned to the Stafford Rosenbaum Appellate Law blog for more coverage. In addition, if you have questions about the Murr case or how it applies to you as a property owner or a municipal government or someone else who has an interest in regulatory takings issues, Stafford Rosenbaum is happy to discuss that.